Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this Courthouse Steps oral argument on the FDA versus wages and White Lion investments. Speaking today, we have Misha Tseytlin, who is a partner at Troutman Pepper, and moderating the discussion, we have Judge Jennifer Perkins of the Arizona Court of Appeals, Division 1. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. And with that, Judge Perkins, thanks for joining us today, and I'll hand things over to you.
Great. Thank you, Edith, and thank you to the Federalist Society for having us. As usual, we have an expert whose impressive bio is one that you should review in greater detail on the event webpage. As Edith mentioned, Misha Tseytlin is not just a partner at Troutman Pepper, he leads the National Appellate and Supreme Court practice. He has successfully litigated several major SCOTUS matters before joining Troutman, and the time frame when I was very fortunate to get to know Misha was when he served as Solicitor General of the state of Wisconsin. Prior to that, he clerked for Justice Kennedy, Judge Janice Rogers Brown, a personal hero of mine, of the DC Circuit, and Alex Kaczynski of the Ninth Circuit. But important for our purposes, he is counsel of record for amicus Logic Technology Development, excuse me, in the case that we are here to discuss today. So before we dive into yesterday's oral argument, I do want to provide a little bit of case history, or actually I'm going to ask Misha to do this for us, just to make sure we're all starting from the same place. So just a few really probably a little bit basic background questions. But Misha, as I understand it, the statutory centerpiece of the case is the Family Smoking Prevention and Tobacco Control Act, which Congress enacted in 2009, which back when they legislated occasionally. As we set this discussion legally, could you just tell us a little bit about that statute and what's its relevant history to this case?
Thank you, Judge, and thank you, Federal Society, for having me on. Just for my own disclaimer before, while I am counsel for Logic in the U.S. Supreme Court as an amicus, and we're also litigating a related matter currently pending on a cert petition, which is being held for the decision here. I'm here today in my personal capacity, not speaking on behalf of my client, and so I just wanted to kind of be clear about that. Now, the statutory scheme, obviously, Judge Perkins gave the full name, is generally known as the Tobacco Control Act. And essentially, what it requires is that before a tobacco product is sold, it needs to get authorization from the FDA. Now, the tricky thing here arises is that it is not provided in the text of the statute that which products will be covered by the statute. In fact, FDA has authority to essentially bring products within the scope of the statute, such that FDA has to approve them before they are sold. So the challenge here is that e-cigarettes, vapes, however you want to call them, were lawfully sold for a long time before the Tobacco Control Act. And when the Tobacco Control Act was enacted, they could still be lawfully sold. What happened is that FDA adopted something called the deeming rule, where it deemed e-cigarettes as tobacco products under the Tobacco Control Act. Therefore, you need FDA permission to sell them. But of course, it would not comply with the due process clause to retroactively require you to have a license for a product that you weren't required to have a license for. So what FDA did is it said, we're going to allow all these products to stay on the market, but you must submit something called petitions for market authorization, PMTAs, to us, and then we will decide whether you can continue to keep selling these products or not. While the decision on those is pending, you can keep selling them. If we grant the authorization, you can keep selling them. If you deny the authorization, then you got to take them off the market. So what companies were doing, or they were scrambling, like, well, gosh, we got to submit these very complicated applications to FDA, in which they said to FDA, hey, you're deeming e-cigarettes to be regulated. What do you need us to provide? What kind of studies do you need from us so that you can, so we can prove to you that our products meet the statutory standards such that they can keep being sold? And FDA gave a series of answers, Q&As, responses to letters, which gave the entire industry a good amount of guidance about what they needed to submit. So then you had more than a million submissions for products to be authorized, submitted to FDA. Many of them had these studies, others had less studies, but everyone was kind of operating from the same playbook that FDA had given the industry throughout this guidance process. And what happened after almost everyone had submitted their PMTAs, had conducted the studies in the way that, and presented the evidence in the way that FDA had asked, is the FDA behind the scenes decided it wanted to get rid of all non-tobacco and at that point non-menthol flavored e-cigarettes. So FDA said, well, they put out something called the fatal flaw memo. They said, if you don't have a certain kind of study with your application, you're going to be denied. And that study was, you basically had to show that your tobacco, candy, fruit, etc., flavored e-cigarette helped adult smokers quit more than tobacco flavored e-cigarettes, which is of course standard nowhere in the statute, nowhere and contrary to FDA's guidance. Of course, nobody had submitted these kind of standards. FDA realized that this memo was illegal. So what they did is they pulled the memo back. They said, never mind, we're not doing the memo. But then they denied every single PMTA based on the same articulated standards in the withdrawn memo. So then there was a series of challenges brought by a lot
Misha,
of yes.
Real quick, just I want to note a couple of specific things because you've covered a lot of helpful information there, and just some facts that I found interesting. And please correct me if I misstate any of these. But so the FDA rule that brought the e-cigarettes and vapes under the statute occurred in 2016, and of course, as you noted, they gave a period of time for folks to file these applications. And then you mentioned there were multiple public information sessions. If anybody listened to the argument yesterday, the 2018 public information meeting was repeatedly referenced. And I just wanted to note, to your point, in September 2019, which is, I think, maybe a year before the applications were due, the FDA issued final guidance with this quote in it, which said, the FDA does not expect that applicants will need to conduct long-term studies to support an application. So this is to Misha's point that all of the pre-application guidance sort of went in one direction with regard to studies. And so as you pointed out in 2020, the folks here and many more applied in September 2020. And then there were subsequent to the applications, additional guidance, which did apparently require long-term studies, and the FDA rejected the application. So getting to where you were headed, the litigation, that started in the Fifth Circuit. So maybe you could talk us through those, the phases of this case in the Fifth Circuit.
Yeah, so there were challenges brought all over the country, challenging the various denials of marketing authorization under this new retroactively imposed long-term study of comparative efficacy with tobacco flavored e-cigarettes. Those challenges were rejected in a bunch of courts. They succeeded at the stay stage in the Fifth Circuit in the wages and white line case. They then lost at the panel stage, and the case went en banc, and the en banc court held that FDA's actions violated the APA and the Tobacco Control Act in a series of ways. One side note, or maybe not a side note, other important aspect of the dispute is that FDA had told companies that one of the things they need to submit is, you know, what kind of measures are you taking to prevent youth from using your e-cigarettes? And this was, you know, the preventing youth use is part of the statutory standard. So companies had submitted the various plans that they were using to keep youth from using their products. And what FDA did is they said, all of these plans, every single possible plan is not going to be good enough because these things are so attractive to youth. So we're not going to even look at the various plans you submitted. And so that position had lost in the 11th Circuit. But then, you know, there was a conclusion in other circuits that even if that was illegal, that was harmless error. So there was a, you know, there was like a two-part circuit split. One was whether the retroactive application of the and change departing from the prior guidance with regard to the comparative efficacy standard violated the EPA and the Tobacco Control Act. And the other was whether FDA's admission that it hadn't looked at the various marketing plans violated the APA and or was harmful or harmless, or if the harmless error doctrine even is appropriate to apply in the administrative law context.
So that kind of brings us up to the Supreme Court. As Misha noted, we had, you know, the ultimate ruling out of the Fifth Circuit in this particular case. It was an en banc ruling. Judge Oldham authored a 10-6 majority, and there was a primary dissent and a second dissent. And there are several holdings, but the upshot is they found that the FDA acted arbitrarily by changing application rules without proper notice. So here we come to the Supreme Court. I think there's an interesting note on timing, so I'm just going to throw it out there, and we might pick up on this later, which is that the court granted cert. All the petition filings occurred in the spring, but the conference at which the court considered the cert petitions was on July 1, 2024. A couple of noteworthy administrative law opinions had come out in the interim. I don't know how directly they all impact this case, but they certainly have caused a lot of discussion about the current court's view of the administrative agency processes. So we might come back to that. But the question presented to SCOTUS, as articulated by the court and in the briefs, is whether the Court of Appeals erred in setting aside the denial orders as arbitrary and capricious. Before jumping into the oral argument, was there anything that you wanted to touch on in terms of the parties' briefing or the arguments that they made there?
Yeah, I wanted to, and because it is an important wrinkle that was brought up at oral argument, you know, the issue of with the primary circuit split arose with regard to flavored e-cigarettes, fruit candy flavored, fruit flavored, and those are an important part of the e-cigarette market. However, what FDA did is, while these litigations were going, is it took the comparative efficacy standard that it had retroactively imposed on these candy and fruit flavored e-cigarettes, and it also had decided to impose them on menthol flavored e-cigarettes, which is of course hugely consequential because menthol cigarettes are lawfully sold in the United States. They're about a third or a little less than a third of the combustible cigarette market. So FDA taking this additional step of imposing retroactively this comparative efficacy standard on menthol flavored ends, ends is industry colloquial for the e-cigarettes or the vapes, was, you know, hugely, it took an issue that was already important and made it even more important. We submitted a petition for certiorari on the menthol issue, hoping to get it heard at the same time as the fruit and candy issue. The Supreme Court appears to have decided to hold that petition until it resolves the wages and White Lions case. But it is a very important additional action that's going on, kind of not in the background, in the side here, which is potentially implicated by this case and would have much broader negative consequences for those attempting to quit menthol cigarettes than, you know, the candy and fruit flavors that are at issue in this case. Now, in terms of the parties briefing, what I found pretty remarkable about FDA's briefing here is that while the retroactive application of the comparative efficacy standard is the core legal dispute that was rolling across all the circuits, and that all understood was the heart of the legal dispute here, and also all understood was the basis on which FDA had denied all these applications. FDA's brief at the U.S. Supreme Court, submitted by the Solicitor General's office, essentially ignored this and tried to make it seem like, oh, there was just like not enough evidence for these particular applications, and gosh darn it, if they'd only submitted more evidence, maybe they would have gotten approved. And, you know, it's just a real coincidence that, you know, all 1 million candy and fruit flavored PMTAs were all denied on the same basis. It's just like the industry was just confused. And so they attempted to kind of, rather than hitting head on and defending the retroactive imposition of the comparative efficacy standard, they attempted to muddy the waters to try to make it seem like this was just an all things considered judgment by the agency. Maybe that's an effective strategy. I guess we'll see. You know, we'll talk a little bit about the questions of oral argument. I tend to think it's not an effective legal strategy. I think the court is not so easily fooled. Whether FDA wins or loses at the U.S. Supreme Court will ultimately turn on whether the Supreme Court thinks the comparative efficacy standard was within the ambient of what FDA could require, whether in fact the prior guidance, like the one that Judge Perkins read, was sufficiently clear such that parties were misled, and other such considerations. I don't think the court is gonna be as, you know, easily misled as apparently the Solicitor General thought that they would be by essentially burying this issue in their brief.
So, and that actually dovetails with one of my first questions, because I was maybe struck is the right word by some of the questions that Justices Kagan, Sotomayor, and Jackson had for Mr. Heyer. You know, he had an introductory statement that walked through the before and after, you know, before the applications, here's all the things that we heard from the FDA, and after, this is what happened. To your point, Misha, we were all rejected on the same basis for the lack of a study. So everybody understood it to be that way. But the three justices I mentioned were, I don't know, seemed very flummoxed by Mr. Heyer's position in saying there was a change. They all said there was no surprise here. This was all consistent. The FDA made pre-application statements regarding concerns over flavored liquids, and that was enough to put the companies on sufficient notice. So I guess to your point about the core issue, it does seem, at least for some of them, or, you know, at least taking them at face value in their questions, they don't believe the FDA changed anything here. There was nothing that altered. What did you think about those questions? Do you think they were taken in by the Solicitor General's brief on that? Is there something else going on there?
Yeah, look, as I listen to their questions, especially those from Justice Jackson, I think those justices were, with respect, confused as to what the Tobacco Control Act requires, because the Tobacco Control Act does require a consideration of whether it will help adults stop smoking. They seem to confuse that with the very different requirement that FDA had retroactively invented, which is whether the products that are being, the flavored, the candy and fruit flavored e-cigarettes are better at helping you to stop smoking than tobacco flavored e-cigarettes, which is not in the statute. And nobody had any reason to think that that's the studies they needed to submit, which is why nobody at the time submitted those studies. It struck me from Justice Jackson's questions, was I think Justice Kagan and Justice Sotomayor were piggybacking on. They thought that the comparative efficacy with another deemed product was what the statute was asking of, and so that the guidance, that as they read the guidance, it would have been in light of their misreading of the statute, and therefore they're asking, well, the statute already requires this. How could you be misled by FDA's guidance? You could just read the statute, and obviously the guidance that they gave is in light of that statute. But once one recognizes that the comparative efficacy versus another deemed product is found nowhere in the statute, then those questions, I mean, with respect, I say don't make a whole lot of sense. And also, it's just, it really blinks reality. I mean, obviously, some of these folks who are submitting these applications are smaller players, but there are also a lot of very sophisticated players. It just like beggars belief that everybody in this industry just got confused in the same way. And I thought one of the things that drove me the most, drove me up the wall the most was the SG's lawyer saying, well, look, we approved a couple of menthol flavored PMTAs, just a couple of months ago. So obviously people knew, but literally those folks had amended their PMTAs after FDA revealed its new approach. And the new studies that they cited in their amended PMTAs were the basis of the grant. It seems to me that that is powerful evidence of the switcheroo, and the fact that this one company had happened to get at the back of the line, so it hadn't been so unfortunate as to have already been denied. So before it was denied, it was able to amend its application and get these new studies in. I think just very powerfully shows that it is not a serious argument that anybody had, including that company, had notice of the standard before, because otherwise why would they be amending their applications? It doesn't make any sense. But it seemed that Justice Jackson, also probably Justice Kagan and Justice Sotomayor, thought that the guidance was already in the statute. And so whatever FDA said was just putting color on that, and everyone should have known what nobody knew.
Well, jumping off the mention of those later applications, and to one of your earlier points, I think it was Justice Alito that mentioned the interaction between the candy and fruit flavors and the menthol flavors in other cases. Was there anything about his questioning or that discussion here that you think, or I guess that you wanted to comment on?
Yeah, I mean, obviously, as a matter of both atmospherics and substance, the issue of candy and fruit is tougher than the issue of menthol flavors. I mean, the products here, had child-friendly names, at least some of them did. And so, it creates a different impression than when you have products that are flavored like legal combustible cigarettes, menthol cigarettes, and that FDA is treating those as categorically different than tobacco flavor ends. There's no reason why, why wasn't the comparative efficacy candy and fruit versus menthol? It doesn't, there's no statutory or reasoned basis for it. It's just that FDA decided that it wanted to take certain types of ends off the market, and it wanted to do it as much as possible. And so I was certainly heartened by Justice Alito's questions, because of course, one of the worries that those who wanted the court to take the menthol ends case as well have is that the baby is not thrown out with the bathwater. We had some questions from some of the justices, which I'm sure we'll get into, about what's the big deal if we deny, if we grant you this relief, aren't you just going to be denied anyways? And whether that's true or not true for candy and fruit flavors is certainly not true for menthol. And if the court is going to go, with respect, the wrong way on this issue, I would hope that Justice Alito's questions will push them towards making clear that menthol flavors are a different category entirely than candy and fruit.
Yeah, so I do want to get into those sort of practical reality questions. In fact, we have a question from the audience on that. But just briefly, I want to touch first on, so a fair portion of the argument took up what you had mentioned earlier, the harmless error issue. So as I understand it, the FDA, as you pointed out, the FDA refused to consider the marketing plans submitted with the applications, but has since they're essentially not defending that, sort of conceding error on having failed to consider them. But their position is this is harmless error, as several of the justices, Chief Justice Roberts, Justice Gorsuch, others, commented on the Chenery problem. I think it's SEC versus Chenery, the case that they were referring to. Can you talk us through a little bit what's the harmless error / Chenery problem issue that they were discussing?
Yeah, so under the Chenery doctrine, which comes up quite a bit in administrative law, an agency decision can only be upheld on a basis found in the administrative record. So, clever FDA lawyers can't come up with a new rationale not found in the PMTAs to uphold an agency action. So, let's say that the comparative efficacy standard was thrown out, but there was another reason why the wages in White Lion application was deficient that wasn't mentioned by the agency. The lawyer in court can't be like, hey, don't worry about that problem because you got another problem. You got to send it back to the agency under the Chenery doctrine. You can't uphold an agency rule on that basis. The harmless error doctrine is a little bit different depending on how you look at it. On one hand, it is like Chenery in that the agency does not say in the administrative record that even if we had looked at the applications, we still wouldn't have denied them because they have not looked at the application, so they couldn't say that. The harmless error doctrine here, if it's seen as different, is it's more like an efficiency thing. Like we know what the agency is going to do anyways, so why waste the time? I think they're the same thing. Ultimately, I think they boil down to the same kind of administrative law formalist distinction, but there was certainly a lot of questions about that oral argument. Now, I think one of the problems with invoking harmless error in the administrative agency context is administrative agencies do have, even after Loper, some amount of discretion. And, as we know, there's going to be a new sheriff in town overseeing the FDA. So by the time the PMTAs were sent back to FDA, the new administrator may have a different view of these marketing plans. And there's no binding precedent or anything from FDA on these marketing plans. So theoretically, the marketing plan could be deemed sufficient by a new administrator. And we have here a happenstance of a change of administration, but it could be the same administration and a different administrator. Unless you think that's fanciful, when I was talking about the menthol flavored ends issue, all of the career staff, and this came out with a couple of extraordinary internal memos that the staff essentially forced FDA leadership to release, had said the menthol flavored ends should be approved because they're so important to menthol flavors smokers. And this was administrative staff under the Biden FDA. Now the FDA came under political pressure. New leadership essentially overruled the career staff, believe the science, all that. And so even within the same administration, you saw a change. So certainly that can happen within administration. It can happen, and certainly happens a lot when administration changes. And while one of the reasons that getting rid of Chevron and Loper was so important is to stop the whiplash when statutes mean two different things under two different agencies, under the now dead doctrine of Brand X, the same kind of dynamics that played under Chevron still continue to play in areas where the agency does have leeway, which is outside the statutory interpretation context.
So I think that's a nice lead in to the practical questions. I think that was sort of a focus for Kavanaugh in particular, but also Justice Barrett. I think Justice Kavanaugh's point was, either way, whatever the outcome, the answer is sending it back. That is the relief. The relief is being able to reapply ultimately. Did you have any thoughts on that line of questioning?
Yeah, I mean, that to me was maybe the second most frustrating part of the oral argument, because I think Justice Kavanaugh was not sufficiently appreciating the manner in which the deeming rule worked. As I talked about at the top of this presentation, because these were lawfully sold products and they couldn't be forced to be yanked off the market immediately, you go to a vape store, those are lawful enterprises generally. Those products are sold, can continue to be sold without any FDA enforcement until FDA denies your marketing with authorization application. So if you send it back to the agency and you vacate the denial of your marketing authorization, then you get to stay on the market while your application is considered. Whereas if you're denied, your product's off the market, and for many companies, it means they will go bankrupt. And even for those that don't, they may discontinue their line of ends and stick to combustible cigarettes, or stick to combustible cigarettes and tobacco flavored ends. So, and then you'll see this dynamic also in the menthol flavored ends with regard to that one company, Enjoy, that I had referenced, where they had managed to get their new studies that met the comparative efficacy standard that because they were at the end of the line and they hadn't been denied yet. So essentially, a company like that, under the Kavanaugh contemplated approach, will essentially get a monopoly under the entire market, because while everyone else takes 3 years to submit their studies and get it authorized. I mean, that's no way to run a railroad, and certainly nothing in the Tobacco Control Act contemplates that. And so I think, hopefully the answer to the oral argument was good on that. Hopefully Kavanaugh will go back and see that the practical import of not vacating the marketing denial orders is to yank the product off the market, whereas other products are on the market, they steal your whole market share and they destroy your company.
So a sort of secondary question in our audience question on this area of remedies is, what if the justices decided to take the narrower path by affirming the Fifth Circuit only in terms of the error and not reviewing the marketing plan? I guess my impression was, based on some of the discussion at the end, that this, of course, the Fifth Circuit stay of the denial maybe remains in place, so that the companies are still able to sell. But I don't know if you had thought about that at all.
Yeah, I mean, if they remanded to the Fifth Circuit to decide whether it was harmless error, then presumably the Fifth Circuit stay will remain in place. If instead they held that harmless error is not available, then presumably the marketing denial orders would be vacated, and the product would continue to be sold under the deeming rule.
Okay. I'm actually just we've got a couple of other audience questions. I thought I would just go ahead and jump to those. From Mr. Troutman, what surprised me is that FDA's imposition of an improper, quote, tobacco product standard was not discussed. That seems like a layup for the industry and a really good chance to coax the court to overrule Chinnery 2, which is not the Chinnery case discussed at argument yesterday, but a subsequent case, noting this may have been a missed opportunity. I don't know if you had any thoughts on that, Misha, on the lack of discussion about the tobacco product standard.
Yeah, well, so I mean, obviously Greg is a very noted attorney in this area. And, certainly that tobacco product standard issue, as well as the issue, whether FDA could require this kind of comparative study, comparative efficacy mandate at all, even if it put out a rule, are issues that are out there. I think that the U.S. Supreme Court took review on the surprise switcheroo issue. I think it is arguable whether those other issues were fairly encompassed in the questions presented. Certainly, it seemed like the justice did not think that that was part of the case. So presumably the court will not decide that, and that will remain one of those twin issues will remain to be litigated, unless of course the FDA changes its position again and sees the light and then gets rid of the whole comparative efficacy standard.
Another question says, some of Justice Sotomayor's questions misunderstood how vape products work, i.e. her notion that flavors mask an inherent tobacco flavor, or that the only purpose of vaping is to addict new users. Why do you think she was so uninformed, and will that work against her and other justices that might wish to side with the FDA in conference?
I mean, certainly there were some questions from Justice Sotomayor that did not correctly reflect the nature of the products. What I will say is that, those who attend these webinars and litigate these cases are often, this is either their primary work or, one of their primary areas. The justices are deciding a lot of very, weighty issues all over the place. A lot of times you'll get questions at oral argument that are not as well formed as they could be. But by the time justices put out their opinions, we watch the oral arguments and we get a lot out of them. But the actual work of the court, the thing that that they're really signing their name to, is their written decisions or dissents. And so I expect that kind of stuff will not be, any sort of misunderstandings of specific things will be worked out, and by the time they put out their opinion, you won't see that kind of thing. And I think the other justices are likely to give grace to Justice Sotomayor if she misstated one thing or another, because they all misstate things from time to time, because the justices are human and there's a lot of complicated things in front of them. Each sitting has a lot of, while the court's docket isn't as big as it used to be, it's still pretty weighty, and they have a lot of cases that they're reading about at the same time.
Another audience question, is there inconsistency here in how the FDA is regulating Zins and other nicotine pouches with fruit-type flavors that can be marketed to kids?
I mean, I don't know about that question in particular, but I do think it is remarkable that FDA has allowed truly irresponsible companies to market to kids without taking any meaningful enforcement action against them. And FDA knows who those companies are. Anyone that goes, you can go into a vape store and see those products out there, while it's deciding instead to use its limited resources to, for example, go after responsible menthol flavored companies that don't sell any meaningful amount to kids, to go out of their way not to market to kids, while it just seems like a misallocation of agency priorities at minimum, and perhaps worse.
So no audience questions pending, and I think we got through at least the points of argument that I thought were interesting, being somebody who's not nearly so well versed in the area as you are. I wanted to give you a chance to just sort of close this up. Were there any other, were there any surprises from argument that we haven't talked about? But was there a takeaway that you think the audience should be thinking about as we're waiting the long months for the decision?
No, I think we covered all the things that I wanted to cover. Obviously, the big wild card here is what is the new FDA administrator and leadership going to do on these issues. The changes with regard to the treatment of e-cigarettes were coming fast and very irregularly from FDA. What happened with the release of these internal memoranda, and this wasn't a leak of the memorandum. It's clear to me that the staff forced the agency to put what they had done in writing because they were so livid about what the agency had done, that these are the kinds of decisions that I think might be ripe for reconsideration with a new leadership. But of course, they're going to have a lot of other priorities, so there's no way to tell what that change will be or whether it will come before or after the U.S. Supreme Court issues this decision.
Great. Well, Edith, I think we've wrapped for today. do you have any closing thoughts?
Yeah, on behalf of the Federalist Society, we thank you so much, Misha, for speaking with us today, and Judge Perkins for moderating. We're so grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.